It's time again for Legal Talk on eRadio with Hahn and Hahn Attorneys, and today joined by Associate Attorney Isabella Mazzone. And we are talking about cancelling lease agreements. Can my landlord charge me penalties? This is also one of those hot topics that we often get questions on, people wanting out of lease agreements for obvious reasons. Anyway, Isabella, it's nice to have you back on Legal Talk. Hope you're well.
It's nice to have Legal Talk. It's nice to be here on Legal Talk with you as well, Ian. Thanks so much for having me.
Yes, welcome back. So, firstly, how can I cancel my lease agreement early if there's no termination clause?
So if your agreement does not make provision for an early cancellation, then you will rely on the provisions of the Consumer Protection Act as well as the Rental Housing Act. If your lease agreement does make provision for early termination, then you will have to rely on the clause, subject to the fact that it is, of course, lawful, meaning that if it has anything in the clause which does not comply with the applicable laws, then you would be able to challenge this. If the parties agree to a notice period in the agreement, either party may then give notice and the agreement will terminate as per the terms of that agreement. But if no notice period was agreed to in this agreement, but early cancellation was provided, the parties may then rely on the common law principle of 1 calendar month's notice.
Okay, and what does the law say about a tenant terminating their lease agreement early?
So the Consumer Protection Act specifically allows for early termination and provides that it is permitted subject to the fact that it is, of course, a fixed term lease agreement, meaning that it's for a specific period of time, and that the person entering the agreement is a natural person and not a juristic person like a company or something like that. But Section 14.2 of the CPA provides that the tenant must give a minimum of 20 business days written notice to the landlord with their intention to terminate the lease agreement. It's really important to note that the tenant will remain liable to the landlord for any amounts that are currently owing to the landlord in terms of the agreement up until the date of the cancellation. And the landlord is also well within his or her right to impose a reasonable penalty. When it comes to your deposit, the landlord is also required by law to invest this deposit in an interest-bearing account, with interest accrued being owed to the tenant. And landlords are required to return the tenant's deposit within a reasonable time after the termination of the lease, unless another clause is provided for in the lease. The cost of any repairs that the landlord has to make for damage caused by the tenant can be deducted from the deposit, as well as any other amounts still due and owing to the landlord. But these damages obviously can't go beyond normal wear and tear, and the landlord's not allowed to use the deposit for general maintenance of the property or any upkeeping of the property. The tenants are responsible for any outstanding rental arrears and damages, and it's really essential for tenants to understand their obligations in this respect.
Okay, and what exactly is a reasonable penalty fee?
So the reasonable penalty fee that they are allowed to charge you if you terminate your lease agreement early can actually, the provisions that provide for this can be found in Regulation 5.3 of the R293 CPA regulations, the Consumer Protection Act regulations. And there they actually provide guidelines in this respect. There's no clear definition of how to calculate what this reasonable penalty fee is, but rather a broader guideline. And here they stipulate that the reasonable penalty, credit, or charge may not exceed a reasonable amount, taking into account the amount which the consumer is still liable, the value of the lease, the value of the goods which remain in the possession of the consumer. If, for example, there was still furniture in the apartment, the duration of the agreement, any losses suffered, and various other factors included in this regulation. Above and beyond that, the supplier may not charge a charge which would negate the consumer's right to cancel this fixed term agreement, which is afforded to them by the Act. So in general practice, the factors that are truly considered in this respect is the actual loss sustained by the landlord due to their inability to find a new tenant, any advertising costs, Property 24 costs, private property costs, the advertising of this property that must now happen, and any fees that the rental agents may charge them. So it's really important to note that the landlord must prove in this instance that they attempted to mitigate their damages. So they put in effort to make sure and positive steps to find a new tenant. But in general, an amount equal to 2 months of rental is awarded if the landlord is unable to find a new tenant.
And our final question for today, what should I do if a dispute arises between myself and the landlord due to this early cancellation?
So in cases where disputes arise between landlords and tenants regarding early termination, it's advisable to first attempt some sort of mediation or negotiation with the landlord and to reach mutually acceptable terms and a resolution in this respect. It's normally quite loose in that respect, but if it goes further than that, mediation services may also be available through the various rental housing bodies. If this mediation still fails, then either party can still seek legal recourse through the appropriate channels, such as the rental housing tribunal or, of course, the court. But it's really important that both the landlord and the tenant seek legal advice in this respect and understand what their rights and obligations are before pursuing this legal action.
Okay, and we hope today's legal talk shed some light on this matter, especially for our listeners trying to get out of a lease agreement for whatever reason. Isabella,
No, absolutely.
As always, thank you so much for your time.
No worries, Ian. Of course, I think it's just very practical knowledge. I myself had to deal with early cancellation of a lease this year. So even I am glad to have brushed up on the things that would assist me as a tenant in this respect.
Okay, yeah. First-hand experience.
First-hand.
Thank you so much. That's Isabella Mazzone from Hahn, where she is an associate attorney. That is it for this week's Legal Talk.
Are you or your business in trouble and struggling to find a solution? Call Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn Attorneys, Wednesday mornings at 10 on eRadio.